Laches, slacks, and gold jackets. Apparently getting a fancy jacket is a thing in pro sports. We all know the green jacket in the Masters golf tournament, and there are other jackets in golf too. There's a red one, even 2 tournaments that give out plaid jackets. In pro football, inductees to the Hall of Fame get a nice gold jacket. That gold jacket was part of a trademark lawsuit that was just dismissed in Florida. The suit was brought by the heirs of Victor Maitland, a retired advertising executive. He helped transform a loose group of former NFL players called the NFL Alum into a successful charity, and he was involved in developing the gold jackets. Maitland passed away in 2019 at the age of 98. Last year, his estate sued the NFL, however, claiming that the NFL had misappropriated his intellectual property by continuing to use the gold jackets and associated emblems without his permission. Last week, the federal court hearing the case in Florida ruled that too much time had passed since the NFL began using the jackets for Mr. Maitland to complain now. The court explained that the plaintiffs would need to rely on evidence beginning as far as 49 years ago, when Mr. Maitland first joined the NFL Alum. And as the court said, if there were ever a case where improper delay would apply and where defendants would be prejudiced by that delay, this is surely one. You've probably heard about statutes of limitations. That's how long you can wait before you bring a case. But here's a fun fact about the Lanham Act, which is the primary federal trademark statute. It doesn't have a statute of limitations. Now, while some courts look to the most analogous state law for a statute of limitations, courts also apply the equitable doctrine called Laches. Laches rhymes with latches like a door latch, even though I was in a hearing one time in Atlanta where a federal judge said it is pronounced Laches with a French accent, which does sound fancier. Laches is the equitable concept that waiting too long to sue will bar the claim if the delay prejudices the other party. For those who really want to nerd out on legal history, back in the day there were courts of law, where you sued for money, and there were courts of equity, where you sued to get a court to force someone to do something or to stop doing something. In the equity courts, where you might not even have a jury, the judges often applied rules of fairness in ways that may not have been allowed in the law cases. And if you're really curious, this is part of why the 7th Amendment to the Constitution refers to the right to a jury trial in suits at common law. Well, at least in suits at common law involving more than $20. Now that's $1789, mind you. According to Etim Online, which I think that's how you pronounce it, is an online site about word origins, the historical uses of latches refer to negligence in the performance of a legal duty, or even a slackness, a negligence or want of zeal, coming originally from Latin terms to slacken or relax, and loose, yielding, indulgent. In other words, quote, to be slack or languid. If latches means being slack, that's an interesting coincidence, given that Hager Clothing was one of the co-defendants in the case. Hager is the clothing company that actually makes the gold jackets, and on its website, Hager claims to have coined the phrase slacks in the 1930s as a take on the term leisure time or slack time. The idea is that Hager slacks would be worn during the slack time, away from work. The word slacks is pretty generic now, and referring to pants as slacks, or trousers, may lead to other questions, such as, just how old are you? If you like this kind of stuff, you can like this video and subscribe to our channel. And you can also sign up for the newsletter in the link in the description. Even if you don't like trademark and franchise law, you can enjoy the occasional pictures of our canine law clerk at work and our regular trivia questions. We hope you enjoy.